At this point, let's get more reactions from a Duterte ally, and joining us is former presidential spokesperson Harry Roque. Good evening, Atty. Roque. Unang-una po, are you following the confirmation of charges hearings, and saan po ba kayo?
Every second of it. I'm following it online. In fact, I have an ongoing commentary on the proceedings. No? I'm now in Vienna, Austria.
All right. Well, why not in The Hague in the thick of the action?
Because under the Dublin rules, it was decided that it is the country that issued my visa that should process my asylum. And that country is Austria. And, nakapagtataka na biglang in-schedule itong confirmation of hearing samantalang meron pang nakabimbin na apela sa appeals chamber dun sa issue ng jurisdiction. I would have hoped that the trial chamber will give due respect to the appeals chamber and await the decision on jurisdiction, because if the court decides that there's no jurisdiction, the whole proceedings, this confirmation of charges, would be a waste of time in the first place. Anyway, I'm not in The Hague because the decision to hear this case on the date it was set conflicted with many appointments that I had, including a meeting with DDS ISUG chapter in Munich yesterday. No? And meanwhile, I also have house guests staying with me whom I cannot abandon. But I intend to go to The Hague probably during the birthday of Tatay Tico.
Attorney, I caught your interview with our sister program Storycon, wherein you told them that your passport hasn't actually been cancelled. Can you confirm that?
Yes, I can confirm that according to Austrian authorities, my passport hasn't been cancelled. And it's because I have a pending motion for reconsideration with the RTC that issued the order to cancel my passport.
Now let's go to the confirmation of charges hearing. What do you make of how Attorney Kaufman opened their case yesterday?
Well, I thought it was a brilliant opening statement. No, I think it was good for Attorney Kaufman to have portrayed who Rodrigo Duterte really is. He is dedicated to the rule of law, and he has dedicated his whole life as a lawyer, as a prosecutor, as a mayor, and as president, of course, to law enforcement. No? That, of course, runs contrary to the public perception that Digong is a killer. No? And, of course, it was important for Kaufman to emphasize that this case will be decided on the basis of evidence, not on the basis of political beliefs or political expediency. And what the prosecution has to prove at this stage is that there is substantial evidence to prove crimes against humanity, and that is a widespread or systematic attack against a civilian population, knowing it is being directed against the civilian population. And so far, what I have heard from the prosecution's summation of their evidence falls short of the required standard of substantial evidence. No? They may be able to prove killings, they may be able to prove ordering, but what is the most important element in the crime of crimes against humanity is the mens rea of intent to target a civilian population because they are a civilian population. No? In the words of my house guest, the blogger Maharlika, kinakailangan patunayan nila na ginurguri itong mga di umano mga biktima dahil sila ay mga inosenteng sibilyan. And I don't think anyone at this point has offered any evidence to prove that, which is the most important element in a crime against humanity.
What about using his very own words against him? The prosecution's presentation was peppered with, excerpts of his speeches, even showed a video of him watching a killing.
Well, that's true. It will have some evidentiary value. However, in a criminal proceeding, and even for purposes of confirmation of charges, they have to prove substantial evidence that all this language proves that he targeted civilians because they're innocent civilians. Now, none of the statements that they have attributed to President Duterte, even if we were to admit that they were in fact made by President Duterte, will show that he targeted innocent civilians because he knew they were innocent civilians. He targeted them because perhaps he thought they were involved in criminal activities, which does not mean that they targeted him or he targeted anyone because of being innocent civilians. And that, again, I emphasize, is what makes a conviction for crimes against humanity very, very difficult. In fact, if I would allow me to share, when the Philippine IHL law was new, and because I was one of the major advocates for congressional enactment of that law, I asked many fiscals whom I was training if they were going to use crimes against humanity, and they said no, because that makes our task even more difficult to prove mens rea or mental intent of targeting civilians because they were civilians. If they could prosecute on the basis of murder, they would prosecute on the basis of murder because they just have to prove that there was intentional killing.
Isn't that enough, though, Attorney Roque, that the fact that it's a national policy, which is what the prosecution is trying to prove, kumbaga, nobody had to die by his hand per se, literally, but because it was a policy that he set forth?
Well, the fact that it should either be widespread or systematic is another element of the crime against humanity, independent of targeting civilians, knowing that they were targeting civilians. No? But you see, what they presented today, just this morning, as constituting the policy was Operation Tokhang or Operation Double Barrel. Now, one thing that the defense, of course, will present during their turn of summation of evidence is that Operation Tokhang, Operation Double Barrel, was sustained as far as its constitutionality is concerned by the Philippine Supreme Court. Now, victims, alleged victims, the same victims who went to the ICC, previously attempted to challenge the constitutionality of this policy in the Philippine Supreme Court. Some of the complainants were accorded protection pursuant to the writ of amparo and writ of habeas data, but the petition itself for a declaration of unconstitutionality, because it violates due process clause and other rights of the accused under custodial investigation, were dismissed by the Supreme Court. In other words, they're saying that this systematic policy, which is illegal, is actually a policy that had previously been sustained by the Philippine Domestic Court, no less than the Philippine Supreme Court. And I think they would have a very difficult time now proving that something that the Philippine Supreme Court refused to declare as unconstitutional is illegal and forms part of the elements of crimes against humanity.
But isn't that precisely why they would argue that they had to go all the way to the ICC? Of course, this is all premised that our justice system was not enough, or did not do enough, maybe incapacitated, and was not able to perform their duty at that time for the victims.
Well, that's one issue that the defense will, of course, raise, the defense of complementarity. And if you look at the Index of Law, which is an objective analysis of the rule of law in the Philippines, you would see that their observation is we're not the strongest, but we're not actually a failed state as far as the judiciary is concerned. I don't think it has met the threshold of complementarity that domestic courts are unable or unwilling. In the first place, what the Supreme Court ruled in the case where they threw out the petition against Operation Double Barrel was not an issue of whether or not it was according impunity or immunity to any official, which is what the Rogue statute refers to as unwillingness to prosecute, where there is an impunity statute. It simply said that it did not violate the Constitution because the court said that Operation Double Barrel was simply a police policy to increase police visibility involving knocking on doors and requesting suspected individuals to surrender. And there is nothing in the document that they presented today that would support the prosecution allegation that even the how did they refer to it? High visibility targets, or I'm not sure exactly how it was.
High-value targets. High-value targets.
Were tantamount to a kill list. Because in fact, it's a standard police procedure to have high-value targets, which means that you will prioritize case build-ups against these individuals.
If we could go back to the issue of jurisdiction that is now on appeal, when do you expect that to be heard?
Well, we're just awaiting decision of the court. And what's interesting is after the parties had already submitted their respective positions on jurisdiction, the court, as if indicating that it is seriously contemplating the issue of jurisdiction, asked the parties to make additional submissions. Now, there was an earlier instance when the ICC appeals chamber had to rule on the issue of jurisdiction, and that was when the issue was whether or not to allow the prosecutor to proceed with preliminary investigation, and it was a split decision. 3 judges of the appeals chamber said that the court had jurisdiction. 2 judges, including the chairman of the chamber, the more seasoned, the more senior, the more respected international lawyers ruled that there was none. And so I think this recent order asking the parties to submit further submissions indicate that they are seriously re-examining the earlier decision of the ICC on the issue of jurisdiction because it was a split decision of 3-2.
Now, there are 6 Filipino lawyers who are sitting there in the chamber, though not ICC accredited. They are assisting the group of Attorney Kaufman. Why aren't you there with them?
Well, from the very beginning, the prosecutor already said that they will object to my entry. They had 2 grounds for my entry as defense counsel. Number one, that I was allegedly at that time facing warrants of arrest, which was not true because at that time I was only facing a contempt order from Congress. And number two, that I'm on asylum, which is incompatible supposedly with the functions of a defense counsel. I no longer pressed the issue of representation because the family also expressed that I should take care of my own legal problems as far as my asylum is concerned because they wanted lawyers who could concentrate on the case of Tatay Digong. So I respected the family's decision.
The vice president is saying she no longer expects her father to come back home. What's your
Well, this is a recent development. No? In fact, if you remember, my point of contention with Kaufman was whether or not we could expect a remedy within the ICC itself. I was recommending a remedy on the basis of human rights, which under the International Covenant on Civil and Political Rights was a duty of Netherlands to protect and promote. And of course, we know that the Philippine president is being detained in Dutch territory, in a Dutch jail. He was, in fact, booked by Dutch policemen, examined by Dutch doctors, boarded in a Dutch ambulance. No? And my remedy would have meant to go to a domestic court and allege that there's a failure of the Dutch government to protect and promote the due process rights of the president because he was in fact kidnapped and being detained by virtue of illegal means of kidnapping by Dutch authorities. But anyway, that was under the bridge because the family said we will concentrate on the remedy under the Rome Statute. No? But I think the recent pronouncement of Vice President that the President and she have both given up on the ICC proves my point all along, that the President actually is an existential issue as far as the ICC is concerned. Prior to the kidnapping of the President to The Hague, there was already a debate in the Assembly of State Parties of the ICC whether or not they should continue with the court because they had no other cases, since many of the accused that they have not been apprehended. Accused like Netanyahu, accused like Putin have not been apprehended and have possibly no chance of being apprehended.
All right, we thank you for talking to us, Attorney Harry Roque.